Next to be interviewed, Your Honors, is Secretary of Justice Alfredo Benjamin S. Caguioa.
Good morning, Mr. Secretary.
Good morning to everybody.
So I know you are now ready for interview, so we'll start.
Yes, ma'am.
May I request Attorney Cayosa, please?
Thank you, Madam Chairman. Good morning, Secretary Caguioa.
Good morning.
It states on record that you have been in the private practice of law for the past 27 years. What made you decide to give up your flourishing private practice and join public service in 2013?
A call of duty, and the fact that the president asked me to join him, and I couldn't refuse him.
At the time, you know that the current administration will be stepping down in June,
Yes.
and you know that there will be a limit. But then, if you do join the judiciary, that will be until age of 70.
That's correct.
And wouldn't this be a major sacrifice on your part financially?
Yes, it would.
Because it is indicated in your SALN that there was a tremendous drop from your net worth from 2013 to 2014.
Yes. How do I say this? I'm at that point in my life where I'm just listening to where God wants me to go. So that's where I am.
You could have applied for other judicial positions, but why the position of Associate Justice of the Supreme Court?
Like I said, I'm on this personal journey of trying to contribute as much as I can, and I've assessed myself, and I've looked at myself, and I've said, I think I have some things to contribute to the Supreme Court.
I had the occasion to look at the Department of Justice website, and something caught my eye. In the profile on you, it indicates that you were listed as Chambers and Partners as, and I quote, a leading Philippine lawyer in dispute resolution for the years 2010 and 2011. I wonder why this was stated in your website, and what is the significance of this listing?
I'm also surprised why it's there. That's probably just taken from my website when I was a private practitioner, so it's in my curriculum vitae. So I will make sure it's taken out now, because that's not relevant. Yeah.
But is it true that you have expertise in dispute resolution?
I would like to think so.
Should you become a member of the High Court, how will you utilize this expertise in alternative dispute resolution in order to improve the justice system in the country?
Well, I don't have any specifics. I would think that the first order of business for me, if I become Justice of the Supreme Court, is to find out the specific problems that beset the judiciary, whether at the first level, second level, or the Supreme Court level. At the end of the day, I think the expertise, if I may call it that one generates from the practice of arbitration cases is merely an expertise in having a broader understanding of the workings of any institution. In arbitration, unlike litigation, there's a broader appreciation of the issues and how these issues can be resolved, whether or not they're just by pure litigation or by other means.
Thank you, Mr. Secretary. Moving on to another item that you stated in your personal data sheet. There is this case filed by Attorney Sabino Acut, Martin Pison, and Paul Arias, filed sometime in 1999 for disbarment. It has since been dismissed, but could you tell us something about this case?
It's so way back. I think I was litigating on behalf of a Taiwanese bank, and those lawyers. Okay, I think I remember a little bit. In that particular case, those lawyers acting on behalf of their clients were able to secure a writ of detention of an aircraft that was at that time in Taiwan, and because of that, I think my client filed a disbarment case against these three lawyers. Because they filed criminal cases against him for theft. I'm sorry, but it's really, really way back. But in retaliation for filing that disbarment case by this client of mine, they filed one against me. And it had something to do with the writ of sequestration that was issued by the Taiwanese court, and they were alleging that I had made a material misrepresentation in the affidavit that I prepared for the Chinese client. I'm sorry, ma'am, but it's really a long time ago.
And we just got information from the Office of the Bar Confident that the case has been dismissed.
Yes, it has.
Anyway, a few days ago, we received a letter from a certain Ricardo Benamir. Are you familiar with this person?
No, ma'am.
It's actually a verified letter saying some things about the orders that you have issued as a department secretary. And since you have not, I suppose, not been given yet a copy of this letter?
I was informed about the letter yesterday afternoon, and I think there's a covering note from the JBC that gives me 5 days to reply to that letter, and I will so reply to that letter.
May I just read portions of that letter to give you an opportunity to make a comment, a verbal comment to the allegations stated in the letter. And I quote, apparently, DOJ Department Order number 911 is a continuation of a previous department order, DOJ Department Order number 902, which temporarily designated Associate Commissioner Repiso as Commissioner in charge of the Bureau's border control operations during the APEC meeting. In the last paragraph of the letter, it states that, and I quote, apparently to make Associate Commissioner Repiso the de facto commissioner despite the incumbency of Commissioner Mizon, taint his very competence to apply the law and administer justice with the integrity and fairness expected from a member of the highest court of the land, end of quote. Would you care to comment?
I have to read the specifics of what he says in his letter. I guess what I can tell you is that whatever department orders I have issued in the best interests of the department and in utmost good faith. There were reasons I did that, and there are certain reasons I do not want to disclose before this body for confidential reasons. But as a secretary of the department, and the immigration is a bureau under the department, I have supervision and control over what transpires in those bureaus. And in the exercise of my judgment and discretion, I issue those department orders.
There is a comment, and if I may also just quote, stating that should you be appointed to the High Court, you shall serve to protect the interests of the outgoing administration. How would you respond to that?
My father was a judge for 12 years. I know exactly how the judicial mind thinks. And I know that as a judge, I will wear a different hat, an altogether different hat. And in the discharge of my functions as a judge, I know that I will be confined to what the facts are and what the law is. So whoever made that comment can rest assured that there is no bias nor inclination towards anything in the face of whatever facts are presented before me and whatever law I know to apply.
Thank you, Mr. Secretary. That was my last question, and I wish you well.
Thank you.
Thank you, Madam Chairman. I have no further questions.
Thank you so much, Attorney Caguioa. May I request now Attorney Mejia to continue?
Thank you, Madam Chairman. Good morning, Secretary Caguioa. What is your greatest frustration as a lawyer?
That things moved very slow, that there were a lot of cases where I was involved where the merits didn't come into play, but other matters came into play. I think to any lawyer who practices law in the Philippines, that would be the greatest frustration, and not be in a position to change it.
In law school, one of the first orders of the day, so to speak, is for members of fraternities to recruit you into their fold. I noticed that you're not a member of any fraternity. What is your reason why you did not decide to become one?
Well, like you said, I'm a barbarian. I have no loyalties or affinities to these groups, and precisely, in fact, as you very well know, I became part of a group that tried to entice people away from fraternities. Because in my view then, and as it is my view now, fraternities create relationships that are above the law. And therefore, to me personally, I don't believe in them, and I think they're bad. No? So that's principally the reason I didn't join.
As the current DOJ Secretary, what are the most pressing problems being faced by the department today, and how are you addressing this?
The biggest problem that came to my attention early on was the lack of prosecutors. For one reason or another, the list of prosecutors that had been transmitted to the President had been returned to the Office of the Secretary of Justice for my take. And we tried to fast track that as possible, and we have done so, and it's now again with the President, and if I'm not mistaken, he has already taken active steps to address that problem. I visited regions 7 and 8, I think just before Christmas, just to find out exactly the problems on the ground as far as the regional offices of the DOJ are concerned. And lo and behold, exactly what we feared. No, we have prosecutors who do everything. No, they're the investigating prosecutors, they're the inquest fiscals, then they're the trial prosecutor, and then they have to travel to 4 different courts because there are no other prosecutors in that area. The sheer lack of personnel in the DOJ, I think, is the number one problem that's besetting the department.
In his column, this is related to the initial question of Attorney Caguioa. Dean Tony Lavinia of the Manila Standard stated that department orders numbers 911 and 912 that you have issued are unconstitutional and ultra vires. Can you just briefly comment on that?
I saw that article, and if you notice, he doesn't mention which provision of the Constitution I violated. I stand by my orders. Again, going back, I'm the alter ego of the President, and therefore, we're in the executive department, and everybody serves at the pleasure of the executive, which is the President. So I still believe, and I firmly believe, and I will defend myself against that letter, that those department orders are valid and correct.
That was my final question. Thank you and good luck, Secretary Caguioa. Thank you, Madam Chairman.
Thank you.
Thank you so much, Attorney Mejia. May I request now Attorney Guevara to continue?
Thank you, Justice. Good morning, Secretary Ben.
Good morning.
I'd like to bring you back to more than 30 years ago when we took the 1985 bar examinations.
Where you landed number 2, sir?
No. Do you remember still the very first question in our bar exams on the first Sunday in political law? You don't remember that question anymore?
I remember political law as one of the subjects then that I thought was so difficult because it was asking us to quote constitutional provisions. But I don't remember that specific first question.
Anyway, the very first question in that bar exams was, do you agree with the statement that the judicial branch is the weakest branch of government? I'd like to know your answer to that bar exam question, and also I'd like to find out whether you maintain up to the present whatever your answer to that question was in 1985.
I really don't remember my answer to that question. But I can answer you from what I have accumulated by way of experiences in the private sector and in the public sector. In the sense that the executive touches the lives of the everyday Filipinos in a more immediate and in a more tangible way. In that sense, my appreciation is that it is the executive that has the most tremendous power, and the power of the judiciary does not compare. But in the sense that there must be somebody who would curb the excesses or the mistakes or the acts of despotism of the executive, and that is the judiciary under our system of government, then I would, in that sense, say that the judiciary is even more powerful than the executive. So I guess it's really in what sense you appreciate the question.
Thank you, Secretary. I just have one more question. You're, of course, aware about the ongoing arbitration case between the Philippines and China,
Yes.
regarding the West Philippine Sea.
Yes.
And as you very well know, this matter is now submitted for decision of the Permanent Court of Arbitration at The Hague.
Yes.
All right. Should the Philippine government or the Philippines win that case, and the tribunal state that in fact China has violated the maritime entitlements of the Philippines, how do you think that judgment could be enforced?
I think that's a question that's always in our minds. I think the reason why the arbitration was initiated was not so much to be able to have a piece of paper that we can enforce. It was more as a rally point for everybody who believes in the rule of law, who believes in the treaties that countries enter into, namely the United Nations Convention on the Law of the Sea, to see and to exhibit to the whole world that the Philippines, as weak as it is, stands by the might of the law. No? And that's a question, again, I will have to discuss with the President when we win. How do we, in fact, enforce this thing in the normal sense of the word enforcement? But I think its biggest enforcement is on a practical level, is that we are able to how do you say this, empower the rest of the small countries to recognize that the rule of law, in this case the treaties, would be the one thing that will equalize things for a weak country versus a strong country. I'm talking economic and military.
Thank you, Mr. Secretary. I have no further questions.
Thank you.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman to continue with the public interview.
Thank you very much, Madam Chair. Secretary, good morning.
Good morning, ma'am.
You are now the Secretary of Justice. How would you describe yourself in that position?
Good question. I recognize the powers that come with the office, and they're vast, they're huge, and therefore I realize the big responsibility that goes with those powers. For me, as just following up on what I had mentioned earlier about my greatest frustration, now I find myself in a situation where, in fact, I'm in a position to do good, to dispense justice in the parameters of the DOJ. And that's where I am, ma'am. Trying to find the ways I can wield the powers of the office towards the betterment of the normal Filipino. And It can be in a simple review of a petition for review, a simple disposition of a petition for review. It can be in empowering all the prosecutors all over the country by giving them better facilities. Because the second biggest problem of the Department of Justice is that the lack of facilities. Like I said, I went to Region 7 and 8, and if you go to the City Prosecutor's Office and Provincial Prosecutor's Office of Cebu, they stay in a place that is it's not fit for office work. So one of the bigger things I'm doing right now, or I'm trying to do right now, is to find a way to address that physical problem, and hopefully I will find an immediate solution to all of these things. But again, sorry, going back, I digress. No? But going back to what you were saying, ma'am, with the vast powers that go with the office, for me, it's an opportunity to contribute towards good. As simple as I can put it.
Okay. In that line, Mr. Secretary, what are you doing, or what are your plans to improve the accessibility to justice of the poor and inadequately educated members of our society?
There are a number of programs that are currently ongoing in the DOJ. One of those programs is the IACAT. This is against trafficking of women.
Okay.
And I've seen the passion of the people in IACAT to protect our people. And I've seen as well that they are lacking in resources, they're lacking in adequate space, because they're located in different ports, they're located in different airports, and right now the first order of business again is a physical thing. We have to provide the correct office space, as mundane as that, for those things. When I got appointed in October, ma'am, I knew that I only had 8 months, and therefore I couldn't come up with any grand plan for the DOJ. So it was a matter of prioritizing the existing programs of the DOJ, fine-tuning them so that in the next 8 months, at least while I'm there, I'm able to make things more efficient and therefore, again, directly address the needs of the normal Filipino.
Okay. Let's go to another point, Secretary. Independence is one of the major attributes required by the Constitution for those who want to enter the judiciary.
Yes, ma'am.
Can you tell us your thoughts on judicial independence?
Judicial independence is to be impervious to any kind of influence, whether it's monetary, it's filial, or any kind. Again, I go back to what I was saying, that the primary duty of a judge is to resolve a controversy on the basis of the facts and the evidence, applying the law the way he understands the law. If a judge does that purely, then I assure you, he is already independent.
And how would you reconcile this with the Filipino culture or mentality of utang na loob? Will the appointee, for example, be forever indebted to the appointing authority?
That's a cultural question that I think will bedevil all of us for the next generation or so.
Yes, I just want to know your thoughts on that.
My thought there is a matter of understanding what your role is. In the executive, I know my role, which is to implement the law. In the judiciary, I know I will be wearing a different hat. And that hat and all the learnings I've had as a lawyer tell me that I'm not supposed to have any utang na loob to anybody.
Okay. Now, Secretary, you have been a private law practitioner for 27 years and Chief Presidential Legal Counsel, and now Secretary of Justice. Which positions involved interacting with people.
Yes, ma'am.
Now, if you will be fortunate to be nominated and appointed as a member of the Supreme Court, considering that your the former positions which you held, you were constantly interacting in the former positions. You were constantly interacting with people. Now, in the Supreme Court, most of the time, although not all the time, you will be confined in the four walls of your office, writing decisions and resolutions. Under that situation, do you think you can be an effective member of the court?
I think so, ma'am. At the end of the day, I go back to who I am. Hindi naman ako mabarkadang tao. And the only thing that's important to me right now is my family. So, whatever dealings I may have had in those different positions, they were just professional dealings. When I start wearing the hat, if I'm fortunate enough to be appointed, if I start wearing that hat, I know exactly what that means. It means a change in my lifestyle. It means I will lead a more isolated life. But I'm fine with that. I'm fine with that because I have my family.
Okay. Considering that answer, Secretary, what do you treasure most in your life?
My family.
Okay, that's a good answer. Now, this is my last question.
Yes, ma'am.
In case you're appointed to the Supreme Court, do you think your lack of judicial background or experience would be a setback or a handicap in the effective and efficient performance of your work as a member of the highest court of the land?
Not at all, ma'am. I think as lawyers, we're all lawyers. We're all trained in a certain way. We're all taught how to critically think.
Yeah.
And my not having gone through the MTC, RTC, or Court of Appeals route does not mean, and I don't think it does, that I have a disability in performing a judicial function. At the end of the day, I think we're all taught the same law. We're all taught the same way of thinking and meaning. And by that I mean, as a judge, you resolve on the basis of law and the evidence before you. So, as a lawyer, I knew that very well. And therefore, when I was a trial lawyer for most of my life as a private practitioner, and therefore I knew what evidence to present, how to present it, so that I achieved my hurdle of convincing the judge to rule in my favor. Those are the very same skills, that's the very same mindset that the judge ought to have.
Okay. Although that's my last question, we received a Twitter question for you, specifically for you, and I would like to read it. To SOJ Caguioa. Is it true that he recalled the appointments endorsed by ex-SOJ De Lima?
Sorry,
If
ma'am.
it's true, why?
I don't understand the question, ma'am.
This is not my question. This is sent. We received this by a certain El Mitanyo, and this is a Twitter question. He is asking, basically, if you have recalled any appointment endorsed by then Secretary De Lima in the DOJ.
Appointment? Ma'am, I don't recall. No.
So, okay, on that note, you have answered the question.
Thank you, ma'am.
Thank you very much, Secretary, and good luck.
Thank you.
Thank you so much, Justice Lagman.
Ma'am.
So, good morning again, Mr.
Morning.
Secretary. I believe you are a worthy son of a worthy father
Thank you.
who was my professor in civil law and a recognized authority in civil law. But the question is, why did you not update his book on civil law?
Would you believe, ma'am, that that's exactly what I intend to do in the next 3 years of my life? to update my father's book.
In the next 3 years,
Well-
you will be loaded, supposing you are in the Supreme Court,
That's
with
why-
volumes and volumes of work.
I have a lot
Maybe
of,
you can do that upon retirement.
no ma'am, I have a lot of really good researchers. They can help me.
Oh, okay.
Yes, yes.
So these twin questions are follow-up questions to the questions of Attorney Mejia.
Yes.
You stated a while ago that your problem as a practitioner was the slow pace of litigation. But who is to be blamed? The judiciary? The judges?
No, I think it's an amalgamation of reasons. Lawyers certainly are to be
I believe you. Lawyers should be blamed. You know why? They abuse
Yes.
Rule 65 especially. For every order of a trial judge, a lawyer will always go up to the Court of Appeals, then to the Supreme Court. And it takes years and years
Yes, ma'am.
before this incident could be resolved.
That's correct.
So do you think the Supreme Court, I've been urging the Supreme Court to do this when I was there, should issue a rule punishing lawyers who goes up to the Court of Appeals and the Supreme Court for frivolous petitions or appeals. In America, they are being punished criminally and with fine. What is your thought about this?
I think I completely agree with you that they should in fact be punished. Although I'm not going to go as far as a criminal charge, ma'am.
They should.
But a hefty fine should be sufficient.
So they will learn their lesson.
Yes.
Lawyers are the primary reasons why there is always delay in the disposition of cases. And sadly, it's always the judiciary being blamed, especially by the media. Alright, going to the second problem, lack of prosecutors.
Yes, ma'am.
You know, Mr. Secretary, the reason why? Your prosecutors have been applying for the positions of judges,
That's right.
justices. I
That's
don't
correct.
know why. When I think the salaries are almost equal, you know.
It's only recently, ma'am, that the salaries have more or less caught up. So a lot of the prosecutors before had applied really early on and their applications got processed. And yes, you're right. The attrition rate of the prosecutors is pretty high because a lot of them, well, there's a prestige in becoming a judge. You know? And that's very attractive. Although I have to tell you, ma'am, I've met a lot of prosecutors as well, who really whose entire inclination is to remain as prosecutors, to be the best prosecutors they could possibly be. For me, I think the long-term solution here is really in the law schools. We have to start telling the people who are taking up law that being a prosecutor is a good thing. And on that note, in fact, I understand there's a judicial academy that was planned for prosecutors, and I think that will go a long way in establishing the prestige as well of being a prosecutor in Philippine prosecutorial system.
Next question, Mr. Secretary. In light of the decision of the Supreme Court in the DAP case,
Yes, ma'am.
declared to be unconstitutional,
Yes.
in your honest view, do you think President Aquino, once he steps down, can be charged criminally or otherwise? And also, you know, taking in consideration the operative fact doctrine.
As a matter of law and my appreciation of law and the facts as I know them, I don't believe he should be charged precisely because of those operative fact doctrine and good faith. And in addition, he doesn't fall under the category of an author, proponent, or implementer of this program. What the president did was merely exercise his discretion under the Constitution to augment projects using savings, and that's a completely allowable act on the part of the president, as it is a completely allowable act on the part of the Supreme Court Chief Justice and the Senate President. I don't think he should be charged, but in today's world, he probably will. So,
Yes. Probably he will. He
Yes.
will be charged. We don't know. Supposing he is charged, his defense of good faith can only be raised, as a defense.
That's correct.
Because under that operative fact doctrine, the author, the implementer, and the proponents acting in good faith can be acquitted.
Yes, ma'am.
Okay. So next question, Mr. Secretary. Do you always agree with the decisions of the Supreme Court?
No.
Can you cite? Of course. I also don't agree in several decisions of the Supreme Court. Can you cite one or two decisions wherein you could have dissented if you were there?
I think that decision, the first decision that came out, I thought was wrong.
The DAP.
And the DAP. Because there was a...
Why, Mr. Secretary?
For the very same reasons that were enumerated in the resolution after the decision. The resolution after the decision, to me, was more correct because, among others, there was a mistake on the part of the Supreme Court in believing that an item in the GAA is the same as a budget allocation or an allotment class. And I think the Supreme Court rectified itself in the resolution that came out subsequently and said after an MR. They rectified
So
it.
the resolution on MR bothers you because under that resolution, the authors, implementers, and proponents, if they acted in bad faith, can be penalized. Is that it?
Well,
the resolution,
No, the original decision, ma'am, if I remember
because in the
correctly.
original decision,
Yes.
the good faith or bad faith was not mentioned.
No,
I think
in fact, in the first decision,
that was a good decision as far as you are concerned. The first.
no, ma'am.
Not yet, because the DAP was declared unconstitutional. At any rate, we will no longer evaluate that
Yes,
decision. So, to my question, one or two, another decision wherein you could have dissented.
I can't think of one of recent note.
There are recent decisions like the case of Enrile, the case of Jun Binay, about condonation.
Condonation. Well,
do you agree?
no, ma'am, I don't. I think there.
Anyway, condonation has been abandoned,
Exactly.
but the application is prospective.
Yes.
So you and I agree.
Because
Okay.
at that point in time, when that case was filed before the Supreme Court, there was established doctrine, and the established doctrine is by virtue of a string of Supreme Court cases.
Aguinaldo, Garcia,
Yes.
Garcia Sr.,
Yes.
Sala Lima, and Pascual.
Correct.
The first case.
And therefore, the Sandigan Bayan should not have been chastised for relying on those decisions to
Court of Appeals.
a Court of Appeals, ma'am, for relying on those decisions, because decisions of the Supreme Court form part of the law of the land. So, since the Court of Appeals is not the highest court in the land, they had no choice except to rely on case law. And the case law at that time said that condonation was a valid concept. It's only the Supreme Court really that can change it, and that's what they did. But
In other words, from now on, condonation will no longer apply.
No longer.
Okay. What do you think, Mr. Secretary, is the most disastrous decision ever rendered by our Supreme Court?
the most
Maybe you were still a law student, you were not yet born, but then you have been reading Philippine reports, Iskra, etc. The most disastrous. In America, there is also a counterpart, the most disastrous decision in America.
I can't think of any specific. Ma'am, I have to tell you that my inclination really in law is more civil law than anything else because of my father. So in the field of civil law, there's a decision rendered by the Supreme Court that talks about vicarious liability on the negligence of hospital personnel being attributed to the hospital itself. No? And in that particular case, the Supreme Court relied on United States jurisprudence. And I thought that was incredibly wrong because we have our own law on quasi-delict and negligence, and therefore there could not have been any reliance on any U.S. Supreme Court cases. For me, and since I'm focused on a lot of civil law cases, for me that might qualify as one of the more disastrous decisions of the Supreme Court.
I think it is the decision in Haveliana, if you remember.
This is
Haveliana declaring
political law
that
question.
yes, the Constitution, 1970 Constitution, has become
I think Lanzano versus Garcia and Haveliana.
upon ratification by those people from barangay who just raised their hands.
That's
For
right.
what reason, I
That's
don't
right.
know. Anyway, how about in America? What do you think is the most disastrous decision the U.S. Supreme Court has ever rendered? Which caused the civil war between the North and the South.
I think that's the decision which said that slaves did not have the right to vote. If my memory is correct, I think that's
Yes, the
that will
case of
qualify.
Fred Scott, the Negro, during the time of
Abraham
Chief
Lincoln.
Justice Taney, the decision was Negroes cannot be considered as citizens of the United States under the federal Constitution. Anyway, the warning is there. Thank you very much, Mr. Secretary.
Thank you, ma'am.
So good luck.
Salamat po. Thank you so much to everybody.